5007? Seeing none, the junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President, and I want to thank all my colleagues on both sides of the aisle for this debate. You know, the senator from Bath talked about giving people a fair shake. The senator from Prince William County talked about the cost actually being borne by those defendants that get excessive jail sentences. And it occurred to me while listening to all the excellent presentations by my colleagues that there may be some lay folks sitting in here wondering, give me an example of what you're talking about, this jury penalty. What are you talking about? So let me do that. I read transcripts every week and people that are pursuing various forms of post-conviction relief. Last week I read a transcript, and this happens all of the time. In Hopewell, defendant got into a tussle with a police officer, and he's on the ground, his face is down, and he's fighting him, and he's taking his hand and he's swinging it back, his hand. He's got a knife in his hand, closed knife, blunt, and he strikes the police officer in the neck, in the head, and he bleeds. He gets two stitches. He's in the hospital for 2 hours. He's back on full duty the next day. And he is first charged with attempted capital murder. And the judge says no, throws that out of the preliminary hearing. But then he's charged with malicious wounding of the police officer, 5 to 30. He turns down a plea agreement. The sentencing guidelines call for 1 to 3 years. For the lay folk, low end is 1 year, high end is 3 years, midpoint is 2 years. Turns it down because he had a good defense. He goes to trial, and the jury finds him guilty of malicious wounding of a police officer. So automatically he's got 5 years. But that jury returns a verdict of 26 years. And when the judge comes up for sentencing, he says, you know, the citizens spoke. They decided it was worth 26 years. Nobody thought it was worth 26. Not the detective who I spoke to this week, not the prosecutor, not the defendant, not the defense attorney. 26 years. He's just finished his 9th year, and he's got another 15 years to go. And that, ladies and gentlemen, happens every day in the Commonwealth, in all of our 133 jurisdictions. That's what we call the jury penalty. In Stafford County, prosecutor will make you an offer. If you say no, thank you, he says the following: I'd want a jury trial. Prosecutor demands a jury trial, code for jury sentencing, code for you better watch out. And defense attorneys will not often subject their client to that type of risk, and they'll accept the plea. That means there's a chilling effect on that defendant's constitutional right to have a jury trial. You distribute a gram of heroin, and there's a sentencing guidelines that call for 1.5 years, and the prosecutor in Hanover makes an offer to you. Do you think you're going to take a jury trial in Hanover? And I'm saying this not disparagingly to the citizens of Hanover. I'm saying it respectively. No, you're not, because there's a jury penalty. They could light you up for 30 years at a New York second. So, what does this do? This bill simply says, let the citizenry be involved. They'll determine guilt or innocence, and anybody can demand a jury, the prosecutor, the defendant, or the judge. But let the person who's best able to determine what the appropriate sentence is, the judge who has sentencing guidelines, who can listen to the victim impact statement, make the final decision. That's what this bill does, and we're just doing what 48 other states do. Now, I mentioned earlier that I would address some of the facts. I always enjoy listening to my colleague from Rockingham, and he brought up the following. He suggested that the system is going to implode, that civil litigants will not have their day in court. Folks, that will not happen. Here's a fact. Here's a fact. In 1992, when I was the Commonwealth's attorney in Richmond, I had 16 assistants. We had a total of 17 prosecutors. We did 450 jury trials that year. We were the busiest and largest Commonwealth Attorney's office in the state. 450 jury trials. Fast forward a quarter of a century. The Richmond Commonwealth Attorney's Office now has 40 prosecutors. 40 prosecutors. Do you know how many jury trials they did in 2017? 102. The year before, 93. Twice as many prosecutors, 450 jury trials a quarter of a century ago, 100. And nobody was complaining back in 1992 that we didn't get our day in court for civil litigants. It simply did not happen. My colleague from James City County says that he's profoundly disappointed about this debate. He should be profoundly appreciative that we are having this type of debate to discuss a constitutional right to a jury trial. Can you imagine if we were in 1920 and we were talking about women's right to vote? Can you imagine the argument as follows? You know, I think that's a good thing that the women are allowed to vote, but think of the expense for the State Board of Elections and more poll workers. Let's just wait. Or in 1960, in Gideon versus Wainwright, do you know then that defendants only had the right to a defense attorney in a capital case? So a defendant would go up against a prosecutor for breaking and entering or robbery by himself. Yes, it costs the state more money. But you know what we did? We protected those defendants. And now, 40, 50 years later, every defendant who is subjected to a jail sentence gets a right to a defense attorney. Now, we talked about this fiscal impact, and my friend from Rockingham County said, more judges, more prosecutors, more public defenders. Did I mention in 1992 we have the same number of judges in Richmond that we have today? Do you know the public defenders? Because there's two groups of people that are going to have more, according to the gentleman from Rockingham, we're going to need more people, prosecutors and public defenders. Do you know that the public defenders have run this by their budget folk? Do you know how many additional public defenders they are suggesting we need because if this bill goes into effect? 0. They are not going to ask for one additional public defender. I know my friend, my colleague in the House of Delegates, Delegate Scott, said that he has spoken to many judges, and they want jury trial judge sentencing. And by the way, did you know this? In every jury trial where the jury comes back with a sentence, the judge does the sentencing anyway. 2 months later, he gets a pre-sentence report, and he does the sentencing. There will be no more judges. There will be no more additional Commonwealth's attorneys. There will be no more public defenders. What we will have is a system that is fair. We will no longer chill people's constitutional rights to a jury trial. That's all this bill does. And to think, we in Kentucky are the only two outliers on it. The only people that really object to this, you know who they are? VACA, Virginia Association of Commonwealth Attorneys. You know why? Because they have had the upper hand for the last 200 years. You know what they have right now? They have at their disposal sentencing enhancements. They have mandatory minimum sentences. They can overcharge, and they have what we're talking about today, the jury penalty. I'm feeling so sorry for them that finally we get a system where the jury can determine guilt or innocence, and the judge then can impose appropriate sentence. I feel no pain. I feel no sorrow for those Commonwealth's attorneys. And if it happens, that a certain individual or individuals get primaried because they are involved in the chilling of people's constitutional rights, so be it. I might even help them. I'm Joe Morrissey, and I'm not running for re-election.